The deep dive today is focused on a legal and human tragedy that gripped the nation in the late 1990s.
A truly difficult one.
The murder of 8-year-old Maddie Ray Clifton in Jacksonville, Florida in November of 1998.
Right.
This is a deep dive that it really demands absolute seriousness and empathy.
It does, not just for the victim and her family, which is paramount, but also because the case of her perpetrator, Joshua Earl Patrick Phillips, became a crucial flashpoint.
A flashpoint for what, exactly?
For testing the very limits of juvenile justice in America. It's a case that's inextricably linked to this intense ongoing debate about juvenile culpability.
And the role of environment in impulse control.
Exactly. And whether a sentence that's imposed on a 14-year-old should ever really be considered permanent.
So our mission here is to objectively examine the facts of the crime, the remarkably contentious legal strategy used at trial.
And the constitutional shifts that followed. Shifts that, and this is key, ultimately led to the very high-ranking officials involved in the original prosecution expressing profound public regret.
Okay, so let's set the scene. Joshua Phillips was born in 1984. He was convicted of first-degree murder when he was only 14.
And his victim, Maddie Clifton, was his friend.
His neighbor.
Yes, they were playmates.
So we have a really complex timeline to navigate here. We need to understand the context of his childhood, the disputed details of the crime itself, and then move into how the legal system responded.
Which, as I said, resulted in constitutional change.
Yeah.
But to set the immediate context, the crucial context, after the conviction, Phillips was sentenced to life imprisonment without the possibility of parole.
Yeah.
LIPWOP.
The maximum possible sentence for a juvenile at the time.
Right. But the entire narrative surrounding this case, from start to finish, pivots on his stated motive. He claimed he killed Maddie to silence her screaming after an accidental injury. He said he was driven by what he described as a crippling, profound fear of the punishment he would receive from his father.
His abusive, alcoholic father.
Yes, this environment of fear. It's not just a mitigating factor. You have to see it as the central psychological element we need to understand as we go through the facts of this case.
Okay, so let's unpack that environment. The sources really detail a household that was just defined by tension, volatility, and abuse.
Absolutely.
Joshua lived with his parents, Steve and Melissa Phillips, and the focus, it has to fall specifically on the father, Steve Phillips.
He is consistently described in reports as a drug addict and an alcoholic, and critically, sources confirm he was physically violent.
Towards both Josh and his mother, Melissa.
That's the essential foundation of Phillips's later defense, and it is well documented. Both the son and the mother reported living in constant palpable fear of Steve Phillips.
So it wasn't just the threat of getting hit.
No, not at all. It was the whole psychological climate. It was created by these strict, punitive, and often really unpredictable household rules. The sources highlight that Steve Phillips had a known temper, and his rules were rigid.
And one of these rules became tragically relevant.
Yes.
Specifically, Steve Phillips would become enraged if Josh had other children in the house when he was absent.
And the sources even specify young girls.
Which is strange.
Very. Melissa Phillips, Josh's mother, she corroborated this. She stated she never understood why her husband disliked young girls so intensely, but the rule was absolute and strictly enforced.
You have to imagine the environment this created for a young teenager. This wasn't just a strict household.
No, it was a volatile one where the simplest infraction, like having a friend over to play, could trigger a violent reaction from a man described as a substance abuser with a hair-trigger temper.
And this fear of violating that specific rule is what Phillips claims drove his initial panic when the accident happened.
Right. And it's so important to look at Josh Phillips' profile before November 1998. If he was living in this kind of tense environment, you might expect him to exhibit behavioral problems, maybe violence.
But he didn't.
Quite the opposite. The sources paint a picture of a remarkably normal, non-delinquent child. Neighbors uniformly described him as quiet and friendly.
But no prior arrests.
None. Zero history of violence reported at school or anywhere else.
What about teachers?
His school teacher described him as popular, said he didn't stand out in a negative way. She characterized him as fun and silly.
So this lack of a prior criminal or violent profile is crucial.
It's everything. because it suggests the act was an aberration. It was likely rooted in situational panic rather than some pattern of malice or antisocial behavior.
Which is precisely the argument his later appeals would lean on so heavily.
Exactly.
And we also need to confirm the nature of the relationship with the victim, Maddie Clifton. This wasn't a stranger crime.
No, absolutely not. They are friends, neighbors. The friendship was confirmed by Maddie's own family.
Right. Her mother, Sheila, confirmed it. She said she had no reason to ever fear Phillips.
And Maddie's father, Steve Clifton, also acknowledged his daughter enjoyed playing with Josh.
Even her older sister, Jessie, who had also played with Phillips, described him before the murder as, and this is a quote, a pretty decent kid.
There's even a home video referenced in the sources. It's from about a year before the crime, and it shows Maddie and Jessie being friendly with Phillips, playing with his dog in the front yard.
That kind of evidence just underscores the point that the relationship was typical, neighborly, and seemingly harmless.
Right up to the day of the horrific event. This normalcy is what helps define the shock, the sudden break that occurred when that environment of fear collided with a minor accident.
So now we have to transition to the day everything changed, November 3rd, 1998.
And here we have to rely initially on Phillips's account, which he gave shortly after his arrest. This account frames the entire defense narrative around impulse and panic.
Okay, so according to Phillips, he was home alone.
Already, as we established, in violation of his father's strict rule.
And Maddie Clifton came over and asked him to play baseball.
Right. So the trigger, according to him, was an accidental injury. Phillips states that while they were playing, he accidentally hit the baseball directly into Maddie's eye.
The impact caused her to immediately start bleeding, crying, and screaming.
And it's the screaming, coupled with the sight of the blood, that he says triggered the panic. Specifically, he feared his father's imminent return and the violent repercussions of finding a crying, injured girl on his property.
His response was, it was tragically disproportionate.
And defined by that panic, he claimed he immediately dragged the screaming, injured girl inside the house.
And he noted that her clothing came off her lower body as he dragged her.
His primary immediate goal, according to his statement, was to stop the sound, to stop the screaming that was the source of his intense, paralyzing fear of his father.
And that's when he says he hit her with the baseball bat, to stop the screaming.
Yes, before hiding her under the base of his waterbed.
But the narrative then moves from this panicked assault to an intentional, brutal murder.
It does. Phillips states that after this happened, he actually interacted with his father, who apparently came home, noticed nothing amiss, and then left again.
So after his father left, Phillips went back to his room.
And he discovered Maddie was still alive. She was moaning softly under the bed base.
And it was at that point, realizing the problem hadn't gone away.
That's when he says he removed the mattress, retrieved a knife from a Leatherman tool he owned, and used it to cut her throat and stab her in the chest 7 times.
The timeline that follows this is also critical.
Yes. Maddie's disappearance was reported by her family around 5:00 p.m. that same day. And for the next 6 days, police and volunteers conducted an intense search of the area.
What's so chilling is that Phillips not only maintained his silence, he participated in the search efforts.
He did. He later rationalized this behavior as a coping mechanism. He attributed it to profound denial.
He said he put himself in a fantasy world that nothing had happened.
Describing it as a defense mechanism he used when facing difficult situations as a child.
The search ended on November 10th, and the discovery was made by his own mother, Melissa.
Right. She noticed a wet spot on the carpet in Josh's bedroom, which led her to search the area around the waterbed.
And upon investigating, she found Maddie's body concealed under the bed base.
She immediately fled the house and contacted the authorities.
Phillips was then arrested at school later that day, and it was within hours of his arrest that he provided that confession and the narrative we just reviewed.
And this confession is the core piece of evidence. But this is also where we encounter the deep legal complexity of the case.
Because the prosecution, led by State Attorney Harry Shorstein, they strongly disputed key elements of Phillips's story.
Specifically, the claim of an accidental injury followed by a panic-driven hiding. They didn't buy it.
This is such a critical point, because the difference between an impulsive, panic-driven act and a premeditated or calculated act.
It's the difference between second-degree and first-degree murder in Florida law.
And therefore, the difference between a potentially discretionary sentence and mandatory life without parole.
Exactly.
So what were the specific forensic counterarguments? How did the prosecution try to undermine his story?
They focused on the lack of physical evidence that would be consistent with his description. First, Phillips claimed he struck her with a baseball and then hit her with the bat.
Okay.
Yet police found no blood on the baseball itself.
That's a problem for his story.
A big one. Second, Phillips stated he dragged her and that her clothing came off while dragging her outside the house initially. But investigators found no blood in the backyard, nor was there the expected dirt or sand on Maddie's body that you would expect if the dragging had occurred outside.
So if the physical evidence didn't support the accident narrative, what alternative motive did the prosecution present? I mean, especially given that the autopsy confirmed there was no evidence of sexual assault.
Well, State Attorney Harry Shorstein suggested that the murder might have been sexually motivated, or at least driven by a complex underlying sexual curiosity, even without a completed assault.
What evidence did they have for that?
The prosecution introduced evidence that Phillips had previously discussed sexual matters with both Maddie and her older sister, Jessie.
So their argument was what? That the initial injury was irrelevant.
Essentially, yes. That the underlying reason for bringing her inside and attempting to silence her was potentially linked to some form of sexual preoccupation or attempt, and that the extreme violence of the final stabs indicated malice or intent, which contradicts the simple panic defense.
So the legal landscape is defined by this clash.
It is.
Was it a crime of extreme impulse and fear, made worse by a dysfunctional family environment? Or was it a crime fueled by a darker, potentially sexual, calculated intent?
And the jury would have to grapple with those two very, very different explanations.
So despite being only 14 years old, Phillips was immediately charged and tried as an adult.
Right. In the Florida court system. In 1999, the state's legal framework for juvenile crime was much harsher and offered far less judicial discretion than it does today.
And there was intense media coverage in Jacksonville.
Saturating. Which is why the trial had to be moved from Duval County to Polk County, just to ensure some semblance of an impartial jury pool.
The trial began in July of 1999, and this is where we get to the highly controversial legal strategy.
Yes. Phillips's defense lawyer, Richard D. Nichols, adopted a strategy that was unusual, some would say reckless, given the gravity of the charges.
He called absolutely no witnesses for the defense.
None. This move later became a central point of Phillips's appeals, arguing ineffective counsel. The prosecution themselves later admitted they were stunned by this strategy.
To call no witnesses meant he forfeited the opportunity to introduce any of that crucial contextual information.
Right. No testimony from Melissa Phillips about the violent, fear-driven atmosphere Steve Phillips created.
No testimony from a psychiatrist or a social worker about the impact of trauma on juvenile judgment.
None of it. Nichols' entire focus relied on a gamble.
What was the gamble?
That he could convince the jury during his closing arguments that the death was merely, and this is the quote, an act that began as an accident and deteriorated through panic that bordered on madness.
But without any witness testimony to establish the factual basis for that fear and madness, how could he expect the jury to accept it?
That is precisely the failure of the strategy. The defense's theory panic, caused by fear of an abusive father, was never factually established for the jury.
So all they heard was the confession narrative.
The highly contested confession narrative filtered through the prosecutor's skeptical cross-examination of the detectives who took the statement.
And what's truly unsettling is Phillips's own lack of participation in his own trial.
He never spoke.
He never testified. And he claimed, shockingly, that his lawyer, Nichols, never even questioned him about the events of the murder during their preparatory jail visit.
He alleged that Nichols instead just played chess with him.
That detail, it really speaks volumes about the disconnect between the client and the counsel.
And Melissa Phillips, the mother, she actively voiced her strong disagreement with the no-witness strategy. She wanted to testify about the abuse.
But Steve Phillips, the father,
the very source of the original fear, he insisted that Nichols should proceed exactly as planned.
Presumably because he didn't want his own abusive behavior exposed in open court.
That seems to be the logical conclusion. This parental disagreement and the father's insistence, it cemented Phillips's silence. It prevented the jury from hearing directly about the trauma that allegedly drove the initial panic.
The brevity of the trial just reflects this vacuum of defense evidence. It lasted only 2 days. It concluded on July 6, 1999.
Given the horrific nature of the crime, the speed of those proceedings is astounding.
And the jury deliberation was equally swift.
They took just over 2 hours to return a verdict of guilty on the charge of first-degree murder.
That's a rapid decision. It suggests they likely accepted the prosecution's narrative of malice or intent.
It does. They probably found the violence, the 7 stabs and the cut throat, inconsistent with a sudden panic-driven accident. especially with no contextual evidence to support that fear defense.
And the subsequent sentence was the maximum possible.
Life imprisonment without the possibility of parole. Since he was under 16, he was ineligible for the death penalty. But LIPWP essentially meant the system determined that a crime committed by a 14-year-old warranted permanent, irrevocable punishment.
Before we move on, we have to talk about the two critical pieces of evidence the judge ruled inadmissible.
Yes, because they dramatically shaped what the jury was permitted to consider regarding Phillips's mental state.
First, the defense tried to introduce neurological scans.
Right, brain scans showing bilateral lesions on Phillips' frontal lobe. The defense intended to argue that these lesions were associated with impaired judgment, diminished capacity, and a heightened susceptibility to panic.
A physical, neurological explanation for his extreme reaction.
And the judge ruled against their inclusion. Now, the sources don't provide the precise judicial reasoning, but such evidence is often excluded because of concerns about relevance or potential prejudice.
So the judge might have felt the connection between the brain structure and the behavior was too speculative?
Possibly. That he couldn't prove Phillips's specific state of mind on the day of the murder just from that scan. But excluding it fundamentally stripped the defense of any non-testimonial scientific basis for the madness part of their closing argument.
And conversely, the prosecution wanted to introduce their own evidence.
They did. To reinforce their suggested sexual motive, they wanted to introduce evidence that Phillips had looked at pornography on his computer.
And this was also ruled inadmissible.
Yes. Again, likely on grounds of relevance or undue prejudice. While the prosecution wanted to imply a troubled or predatory mind, the judge likely determined that looking at pornography doesn't directly prove a sexual motive for murder.
Especially since the autopsy found no evidence of sexual assault.
Exactly. So by excluding both the neurological and the sexual preoccupation evidence, the court effectively simplified the case for the jury. It focused them almost entirely on the brutality of the act itself, devoid of any context about his diminished capacity or his potential darker motives.
So the upshot from the trial is that a 14-year-old, deprived of a cohesive legal defense, convicted primarily on the gruesome facts of the crime, and barred from introducing key evidence, received the absolute maximum sentence available.
And that outcome in 1999 marked the beginning of Phillips's life in the correctional system. What the sources detail in the subsequent 2 decades is a profound contrast between the fearful child who committed the crime and the adult inmate he became.
And that contrast became central to his later legal reviews.
It did. During his 2017 appeal proceedings, even the prosecution conceded that Phillips had been a model prisoner throughout his incarceration.
That detail is highly unusual and crucial for the narrative of rehabilitation. We're talking about an inmate who committed one of the most notorious juvenile crimes of the era.
And yet, he actively embraced the correctional pathways available. He completed his GED, his General Educational Development Certificate, and he had to overcome bureaucratic hurdles because of his youth to do it.
And he went on to pursue college classes via correspondence.
His professional roles within the prison structure are equally telling. They speak to his investment in betterment. He works as a paralegal.
A paralegal.
Yes, dedicating his time to assisting other inmates with their appeals and legal matters. It demonstrates not just intellectual capacity, but a commitment to the process. He also tutors others.
So this isn't passive incarceration, it's active contribution.
Exactly. Beyond his studies and work, he engages in multiple structured activities. He plays guitar in a band, participates in Christian religious services, and also practices Zazen and yoga.
This profile of comprehensive rehabilitation and maturity, academic, professional, and spiritual, is precisely what the Supreme Court would later look for when ruling on juvenile life sentences.
And while Phillips was establishing this new identity inside prison, a significant personal event occurred that removed the central catalyst of his original crime.
His father, Steve Phillips,
Was killed in a car accident on June 27, 2000.
so the man whose violence and fear allegedly drove the original panic, was gone less than 2 years after the trial.
Which leads us to confront the complex question of accountability and remorse, particularly regarding the Clifton family.
Right. In 2008, Phillips declined to write a letter of apology.
He did. And his stated reasoning for declining was nuanced. Phillips argued that a simple letter would feel hollow and manufactured.
What did he want instead?
He said that the family deserved an in-person apology so they could look him in the eye and assess the sincerity and depth of his remorse for themselves. He was essentially arguing that a genuine apology required a vulnerability and presence that prison correspondents just couldn't provide.
This decision, whether it was genuine or strategically flawed, was immediately countered by the victim's family.
As you would expect. Maddie Clifton's mother, Sheila, subsequently stated that she had absolutely no interest in talking to Phillips.
Reinforcing the profound, justifiable pain and the emotional barrier that time cannot erode.
For the family, the crime was absolute. No apology, written or spoken, could undo the horror or allow for reconciliation.
And the sources emphasize that this tension, the need for the offender to demonstrate remorse versus the family's right to refuse engagement, is a painful feature of these kinds of cases.
It is. And as of 2024, Joshua Phillips remains incarcerated at the Cross City Correctional Institution, having spent the vast majority of his life behind bars.
This is where this specific case stops being just a true crime story and becomes a foundational narrative about the evolving conscience of the American legal system.
It really does.
Starting around 2008, a movement of conscience began among the very people who had secured Phillips' life sentence. Two officials integral to the original prosecution started to express profound second thoughts publicly.
And this internal reckoning within the system is truly powerful, because it validates the legal argument the defense failed to make back in 1999.
You're talking about Sheriff Nat Glover.
Yes. Sheriff Nat Glover, who had advocated for the original life sentence, publicly stated that it was a tough sentence for someone that young.
And more importantly, he offered a legal assessment that directly contradicted the first-degree murder verdict.
He did. He said, and I'm quoting, "I never got the feeling that it was a malicious, mean-spirited, calculated murder. It was kind of an impulsive act."
That, given a different set of circumstances, would never have happened.
A staggering statement.
Yeah.
The chief law enforcement officer involved essentially validated the defense's core premise years later. Impulse, not malice.
And the regret extended even higher up, to State Attorney Harry Shorstein, who led the prosecution.
Shorstein's regret was focused on a procedural failure. He deeply regretted not offering Phillips a plea deal for second-degree murder.
And this is a crucial distinction that we have to unpack for you, the listener. In Florida, first-degree murder typically requires proof of premeditation or a specific felonious intent.
And it carries a mandatory sentence of death, or, for a juvenile at that time, mandatory LIPWOP.
And second-degree murder.
Second-degree murder, conversely, is typically defined as a killing committed during a non-felony criminal act or one committed without premeditation but arising from a depraved mind, often resulting from impulse or extreme recklessness.
And crucially, a second-degree conviction would have given the judge significant discretion in sentencing.
That's the key. Instead of a mandatory life sentence, the judge could have imposed a minimum term of years, maybe 25 or 30, with the possibility of parole or judicial review built in.
So by not offering that plea, Shorstein ensured the case went to trial on the maximum charge. He left the jury with only two extreme options.
Find him guilty of a calculated murder or find him innocent.
And Shorstein later voiced explicit public support for Phillips's eventual clemency or parole.
He did, acknowledging that the system failed to account for his age and environment at the time of the crime. When the very officials who secured the maximum sentence express that level of public regret, it fundamentally weakens the moral integrity of that original sentence.
And this internal institutional shift coincided with a major external constitutional mandate.
The Supreme Court of the United States ruling in Miller v. Alabama in 2012.
A monumental decision.
It was. It ruled that mandatory life imprisonment without parole for juveniles, regardless of the severity of the crime, is unconstitutional under the Eighth Amendment.
The prohibition of cruel and unusual punishment.
Right.
What were the core psychological and neurological insights that drove the Supreme Court to that conclusion? Because this ruling isn't just a legal maneuver, it's a recognition of scientific facts about development.
Precisely. The Miller ruling acknowledged that children are constitutionally different from adults for the purposes of sentencing. The court highlighted three key differences, all supported by neuroscience.
Okay, what are they?
First, juveniles lack maturity and possess an underdeveloped sense of responsibility, which leads to recklessness and impulsivity.
Exactly what Phillips claimed drove his crime.
Exactly. Second, children are more vulnerable to negative influences and peer pressure, and critically, less capable of escaping volatile home environments.
Like the one Phillips described.
And third, and maybe most importantly, a child's character is not as fixed as an adult's. Their path is not yet determined. This means they possess a greater capacity for change and rehabilitation.
So in Phillips's case, the Miller ruling provided the perfect legal basis for an appeal. It directly targeted the mandatory nature of his life sentence.
Correct. The ruling effectively struck down the system that had convicted him. Phillips's attorneys successfully used Miller to seek a resentencing hearing in 2015.
And he was granted this new sentencing hearing, which was held in June of 2017.
This was the moment the legal system was forced to apply its newly acquired understanding of juvenile development to a case that was already 20 years old.
However, the gravity of the crime did not diminish, and the voice of the victim's family remained paramount. What was their position during that 2017 hearing?
The enduring pain and the demand for permanent justice were clear. At the hearing, Maddie Clifton's mother appeared and requested that Phillips's life sentence be fully upheld.
Which highlights the inherent conflict in these cases.
It does. How do you balance constitutional justice for the offender against accountability and closure for the victim's family? The family argued that the horror of the crime committed by the 14-year-old outweighed the demonstrated maturity of the adult inmate.
So the 2017 ruling, it ultimately navigated this conflict through a compromise.
Yes, Phillips was resentenced to life in prison, but with a crucial modification that made all the difference, adhering to the spirit of Miller.
He became eligible for resentencing review in 2023.
And that transformed his sentence from permanent, irrevocable imprisonment into a conditional life sentence.
And that 2023 date wasn't arbitrary.
No, it's a crucial technical detail you need to understand. That date was set in accordance with new Florida statutes that were passed following the Miller decision.
Laws that mandate periodic judicial review for juvenile offenders who received life sentences.
Right. Specifically, Florida law now generally dictates that a juvenile convicted of a life felony, like murder, must serve a minimum of 25 years before becoming eligible for a judicial review hearing.
And Phillips's crime occurred in late 1998, so 25 years was up in 2023.
Exactly. So the criteria for that 2023 review, as affirmed by the appellate courts, hinge entirely on his conduct since 1999.
And in December 2019, the Florida First District Court of Appeal affirmed this modified life sentence.
But explicitly confirmed it could be reviewed and potentially modified in 2023. And the modification must be based on a judicial assessment of his demonstrated maturity and rehabilitation.
Which means the court has to weigh the mitigating circumstances of his childhood, the abuse, the panic against the gravity of the crime.
But most heavily on the objective evidence of the man he has become. His model prisoner status, his work as a paralegal, his education.
Phillips appealed this affirmation to the Supreme Court of Florida, seeking a more immediate release or a shorter term.
He did, but in June 2020, the state's highest court declined to hear the case. They provided no explanation, which is standard procedure, but that effectively closed the door on further immediate legal avenues.
Confirming that his only remaining path hinged on that 2023 judicial review of his rehabilitation.
So what this deep dive really reveals is a complex arc of justice, one that forced the legal system to evolve over 2 decades.
We started with the raw, terrifying moment of the crime, driven by extreme fear and environment.
Moved through the rapid, arguably flawed trial and the imposition of permanent punishment.
And culminated in the constitutional recognition that children are fundamentally different from adults, a recognition that brought with it the concept of judicial second chances.
You see a profound tension between the two realities the system was trying to reconcile. On one side, the horrific, undeniable severity of the act, the brutal murder of an 8-year-old, which necessitates permanent accountability.
And on the other, the legal evolution acknowledging the lesser culpability of juveniles, especially those who committed impulsive crimes under the influence of severe environmental trauma and abuse.
And the system had to find a way to honor justice for Maddie Clifton while upholding the Constitution's changing view on childhood.
The public statements of regret by high-ranking officials like Sheriff Glover and State Attorney Shorstein are they're extraordinary evidence that the system itself recognizes that mistakes were made.
That the mandatory nature of the sentencing statutes prevented proper justice in the first place. Their regret specifically highlights that a 14-year-old should not have been treated as an adult whose character was fully fixed and incapable of change.
And the enduring interest in this case, which, it continues to be featured on major news programs and deep dives like this, is evidence of the philosophical and legal questions that endure.
It forces society to continually confront whether permanent punishment imposed on a child serves the purpose of justice or simply locks away someone who may be fundamentally, neurologically, and morally capable of reform.
The courts ultimately decided that Josh Phillips's fate should be reviewed based on his demonstrated maturity and rehabilitation 25 years after the crime.
Right.
So we want to leave you with this question to explore. What does the concept of judicial review, specifically tied to the passage of time and evidence of rehabilitation, judging a 14-year-old's crime based on the actions of the man he became years later? What does that mean for the nature of permanent punishment?
If the goal of the justice system is protection and accountability, when does the capacity for change start to outweigh the finality of the initial crime?